Good evening, everyone, and thank you so much for logging in today. We will try and spend the next 1 hour in understanding complete in-depth about estate and succession planning. Of course, 1 hour would not be enough to go into the 100% in-depth, but whatever I can cover in that 1 hour and whatever I can share with you, I will try and do that. Just to give you a brief background about the group, Amicorp as a group, we've been into existence in 92. We've got 40 offices across 28 countries. Internationally, we're very strong in terms of setting up companies overseas and managing these companies in terms of directors, registered office address, whatever it takes to keep the company in good standing. Similarly, we're a licensed trust company internationally and amongst the top 5 globally. We also have funds of our own. We've got a global banking license with a bank based out of Barbados. In India, we've been there since 2005. We have an in-house legal team of 18 people, a compliance team of 35, 60 members on the trust operations, and 25 members on the fund administration. Close to 700 plus employees overall, out of which a large sum is based in our Bangalore office, which is our global back office. In India, we specialize in succession planning, where we help large families to do multiple layers of succession. Depending on the need and requirement, accordingly, a solution can be provided. So we really don't have a product that we are offering or trying to sell here. We are purely a service provider, and we customize our service depending on the need and requirement of every client. Now, before we really get into an introduction to what succession planning is, we'll try and spend some time in understanding what happens if I don't plan my succession. There is no state law that governs your succession. There is no law saying that if I have property in Delhi, what will happen to my property, or if I have property in Bangalore, what will happen to my property. So there is no real state law that controls that. It is the law that is governed is the religion that you follow. So if you are a Hindu family, Hindu succession law will apply to you, which means that it is equal distribution to all legal heirs. Similarly, if you are a Muslim family, it will go as per the Sharia law, which says that the male member gets twice of what the female member gets. If you are a Christian family or a Parsi family, again, it is equal distribution to all legal heirs. But then there are ifs and buts in every community that have been created, which also leads to a few ambiguities in people's mind. Most of the time, we come across families who say that after me, it should go to my wife. After my wife, it should go to my children. That's the most common thought process. Or after my spouse, it should come to me, and after me, it should go to my children. So that's a very common mindset which is there in people's mind. But please, just to highlight again, if that's what your thought is, and you like to do it that way, you need to plan your succession, because otherwise, if you don't plan it, or if you don't document it in some form or the other, it's going to go as per the religion that you govern by. And if you're a Hindu family, then it is going to go equal to all legal heirs. So it's not going to go as per your wish, which says that it should go to my wife, or it should come to me, and then go to the children. So to fulfill your wishes, you need to document this in some form or the other. And the most easiest way to do that is by drafting out a will. A will is a static document that comes in play on the demise of an individual. It carries the wishes of how his or her assets will be distributed. A will supersede natural succession, and assets will be distributed as per your will and just exactly the way you document it in there. Similarly, there are other nuances that come with a will. So there are certain things which have to be taken into consideration. Say, for example, if you are drafting out a will, so there are important parties who are a part of the entire succession. The testator is the one who actually writes out the will. On the other side, you have the beneficiaries who will benefit out of it. The very important part is also the witnesses. A will has to be witnessed by at least 2 people. At any point of time, it is not mandatory to register a will, but it is always advisable that it is registered, because any such document that is there, it is always advisable that it is registered instead of having a document which is open. Does that mean that a non-registered will is not considered legal? A non-registered will is equally considered legal, but a registered document will have more weightage in case of a dispute. Similarly, in a will, in princely states, which they call it, which is Bombay and Calcutta, a will needs to be probated, which means going to the court and getting grant and access from the court that at any point of time, if the will needs to be executed, what would be the workarounds to that? The transfer of assets needs to be done only after the will has been probated. So that again becomes a tedious activity, and it could lead to some amount of contest because a will is a document that comes in play on the demise. You are really not there to express your wishes, and it can be contested at any point of time. It can be contested by your family members. It can be contested by other family members, far off relatives. It can be contested by anybody. To avoid contest, there are other tools that larger families prefer to use, which we will cover in the day today. Coming to a little more in depth, there are a lot of times when there are general questions that, do I really need a will? I have only one son. I have two children. We don't have a problem between the family. Everything is very clear. It can go to the legal heirs in an easier manner. So there is an important point that you need to note that the assets are always distributed in two parts. One is inherited assets and one is self-acquired assets. So if you have inherited the assets, it is again very crucial to see how those assets have been inherited. Say, for example, if you have inherited an asset from your ancestors in form of natural succession, which means without a will, which means that they have passed away intestate, which means they did not make a will. In that case, you will not have the free disposal to will these assets further to your legal heirs in the proportion that you want. Okay, I'll repeat this point because it is a very important one. I have inherited property from my legal heirs in form of a will. This is treated as gift in my hands, and I am free to dispose it to whoever I want in a proportion that I feel. So if I have two children, I can gift it to one and not will it to the other. It is totally my call. But if that same asset or same property I had inherited from my legal heirs or from my ancestors in form of testamentary, which is without a will, in that case, I would not have the right to dispose of this asset to anybody in my family to the extent that I want. It has to go legal. It has to go equal to all legal heirs. So coming back to the point that I have a small family and do I really need a will? Should I really do this exercise? Yes, it is important for you because how your family will inherit this property and how they will transfer it further will depend on that. Again, there are many other factors. If you have a large family, you have a joint family, cross-holding, business houses. So then obviously succession planning becomes even more important for you. There could be certain situations where you have multiple marriages or multiple children from different marriages. Again, planning a succession becomes very important. Currently in India, we do not have inheritance tax or estate duties as they call it, but the way the law is moving, there's a high possibility of inheritance tax or estate duties getting introduced. If that happens, then again, planning a succession will be the only way you could prevent yourself from those kind of issues. Similarly, a will is a static document that comes in play on the demise of an individual. So of course, it is something that stays with you during your lifetime. You have full access to it. You can make as many number of wills. The last will is considered as your final will. Again, there is a very common question asked that should I do it now? Should I do it later? What is the right age for me to do my succession? That's when we had done a small survey. And if you see the graph on your screens, this shows that the highest number of people who said succession planning, the right age is under 35. The logic here is that the moment you start building assets, you should start planning for your succession. So it doesn't matter how wealthy I am. It doesn't matter how many assets or how much money I have. You have something which is important. You have to plan for it to move it to the next generation. Of course, there are other tools that you could use. You could also, so will is one of the ways that you could look at your succession. There are other options that you could use is in terms of gifting. During your lifetime, you could choose to gift as much assets as you like to your legal heirs, but that is something that is not the best thing to do. I would personally not recommend doing that. In my view, the parents should have full access to the wealth, should make full use of it, and then talk about passing it on to the next generation. If you go by the term succession planning, the first thing that comes to your mind is passing on your wealth to the next generation. But if you ask me, I would take estate and succession planning as one. I will not break this up into two. I will not say that succession planning is only passing it on. When I talk about estate and succession planning, for me, it is my estate during my lifetime. I should be benefiting out of it. I should be making full use out of it. And then is the last stage is when I talk about succession planning. So it's not about death here. It's about life. It's about your assets. It's about utilizing your assets for yourself and then passing it on to the next generation. That really brings me to the next tool of succession, which is the trust. A trust is a legal body that comes in play on the demise of an individual. I'm sorry, a trust is a living body that runs parallelly with you. It is something which is running parallelly with you. The assets that you own can be transferred into a trust. You can be a beneficiary of your own trust. At any point of time, you could have complete access to your wealth, and this would be an alternative to your will. A will is used for the assets that are there in your name. If you move the assets to the trust during your lifetime, the assets will belong to the trust for your benefit, and your successors could be the beneficiaries of the trust after you. So a trust is a living body that runs parallelly with you, whereas a will is a static document that comes in play on the demise of an individual. There are two broad categories of a trust. One is the revocable trust and one is the irrevocable trust. A revocable trust is a two-way traffic. Assets can be moved into the trust. Assets can be taken back at any point of time. A revocable trust is a very good tool to use as an alternative to a will, where you don't need to worry about going to the court, getting a probate done. You don't need to worry about anybody disputing the wealth because the assets are already moved into the trust and the underlying beneficiaries or the shares of the beneficiaries are defined. So a revocable trust can be a very good alternative to a will. Few strong cases where a revocable trust could add value. It could be in case you don't have legal heirs. Okay, it's just husband and wife. Over a period of time, with age, you need to take care of your medical expenses, your day-to-day expenses. God forbid if you're in a position where you're unable to contract, then who takes care of you? How do you sign your checks? What happens? In that case, a revocable trust can be a very good option where you can have the set of trustees who you trust or a set of corporate trustees who could then take care of the day-to-day operations, day-to-day needs of the family members. Similarly, a revocable trust could also be used for having a minor child. We are all aware that minors cannot inherit the wealth. So there are very common questions that come across. Say, what if something happens to my wife and me together? Or what if something happens to the entire family together? We have minor children. How will they inherit the wealth? How will the wealth get passed on to them? So again, a trust can be very useful in those situations. The minor children can become beneficiaries of the trust, and the set of trustees or family members who are chosen by you can become the trustees, and the wealth can remain in the trust for the benefit of the legal heir till he or she attains the age of majority or for a longer period of time. So that's again one more advantage of a revocable trust. A revocable trust could also be used in situations for special child. Say that again, the concern is that how does the child manage in absence of the parents? What happens? What not happens? So in all these cases, you have kept your wealth in a revocable structure where it is benefited by you during your lifetime, and it is then looked upon as future generation will be inheriting this property in form of a trust, which will the property remains in the trust for the benefit of the children. Then there is another form of a trust, which is the irrevocable trust. Irrevocable trust is a one-way traffic. Assets can be moved into the trust, but assets cannot be taken back by the settler. When would I prefer an irrevocable trust over a revocable trust? Since the assets of the trust now belong to the trust and not to the settlor, not to the donor. At any point of time, if the settler gets into any kind of litigation or a marital dispute or a business slowdown because of which you got into any kind of dispute, the assets that belong to you can be attached. But the assets that do not belong to you, which means the assets that belong to your trust, cannot be attached. So the great difference between the revocable and irrevocable is, while as the revocable gives me so many advantages, irrevocable will give me a far more advantage because it also gives me asset protection. So if I am looking at getting my children married, instead of giving away a large sum to them during the marriage in their individual name, and then worrying about in-laws, worrying about other people, including in the wealth, I can very well form a trust and give the wealth to my children in a trust, and they can be the beneficiary of the trust. In that case, I can choose to make the spouse the beneficiary or not. So in case if I am getting my daughter married, I can give her a lump sum amount in the trust. She can become the beneficiary of the trust. In that case, a spouse, her in-laws, no one has any access to that particular wealth. So that again becomes a very smart way to protect the interest of your child in the future. Similarly, if I am looking at, I am into business, I am a director in a company, I'm taking loans, I'm standing as a guarantor in many cases, I'm playing a risky role. So at any point of time, if any of my decisions go wrong, there is a very high possibility that my personal assets can be attached. To avoid that, I will set up a trust. I will move my assets into a trust and not be the beneficiary of my own trust. So to get asset protection, you need to relinquish ownership and control. So at that point of time, I will not be the beneficiary of the trust. It will be a one-way traffic. Assets can only go to the next generation or to my spouse who is the beneficiary of the trust. And I do not own those assets directly. Since I do not own them, they cannot be attached. They cannot be linked to any of the defaults that could happen at my level. A trust would also be helpful in terms of NRI beneficiaries. So a lot of us may have children who are living overseas, global taxations, estate duties already in development countries like US and UK. So this could be a very smart way to plan your succession to avoid estate duties and global taxes to a certain extent and protect the interest of your children going forward. There are, like I said, there are two broad categories for trust, a revocable and an irrevocable. A revocable trust, the assets of the trust are considered as assets of the settler and taxed in the hands of the settler. A revocable trust does not give me asset protection, but it is a very good tool to plan my succession and an alternative to a will. Similarly, an irrevocable trust is a one-way traffic. In an irrevocable trust, you have two subcategories. You have a discretionary trust and you have a determinate trust. So you could say that, it's too early for me to decide the percentage of the distribution to my family members. I haven't made up my mind yet how to do the distribution. You could definitely move your assets into a trust and keep it discretionary, where the shares of the beneficiary are not defined. In a discretionary trust, the assets are taxed at the trust level and not at the beneficiary level. Every year or every time you do a distribution, you have the flexibility to choose how much to distribute and which of the family members to distribute at what point of time. Whereas in a determinate trust, you have defined the shares of the beneficiary and it will go as per your discretion, your decision, which you have taken at the time of drafting the trust deed. And then since the shares are defined in the trust, it will be taxed in the hands of the beneficiary. So revocable trust tax in the hands of the settler, irrevocable discretionary tax in the hands of the trust, irrevocable determinate where the shares are defined, tax in the hands of the beneficiaries. So these are three broad categories that you could look at. Alternatively to a will. How does the trust structure really look? I mean, you could have the set of assets which are held under the trust. You have an investment advisory board. So we at Amicorp would never get into giving you advice in terms of how to invest your money. In sense, what to buy, whether you should buy equity, whether you should buy mutual funds, whether you should invest into debt. So we are not your wealth advisors. We are your family consultants. We will be able to help you in terms of how to buy. But what to buy is something that remains with your bankers, and they continue to advise you in terms of what are the underlying assets that you should buy, but whether you should buy it in your individual name, whether you should buy it in your trust, whether you should hold it in a company under a trust. Those are the structuring that we will advise you on. So this is typically how a trust structure looks, where you have the settler who's settling the assets into the trust. You have a set of trustees who will be managing the assets for you. You have an investment advisory board, which comprises of you and your bankers, who will advise you on what to buy, whereas the investments will be done through the trust. And you have the set of family members who are beneficiaries out of the trust. Now, in the family members, it could be you, your wife, your children, your parents, your in-laws, whoever you choose to be as family members can be the beneficiaries. You could also have charity as a beneficiary along. And depending on your needs, you will either take a choice to do revocable or irrevocable. You could also use a trust as an investment vehicle, where saying that, I've not decided in terms of my succession. So I will do up a vehicle where I'll hold all my investments, because at any point of time, the kind of money that's sitting with LIC today, which is not undisclosed wealth, but unclaimed wealth, because of the next generation really not knowing what kind of investments have been done by the future generation, they do not get access to it. So a trust becomes a vehicle where you can pool all your investments and make sure that none of your money gets lost in succession or transfer, and everything gets smoothly transferred to the next generation. So trust can be a very good vehicle to hold your investments also and consolidate your wealth at one place. Similarly, you could buy real estate under a trust. So you set up a trust and you hold your real estate under that. That could be tradable real estate. It could be your family home, the house that you live in, whatever, because then again, you don't need to worry about transferring that real estate to the next generation through a will. Then there are some large business houses which also set up trusts for holding the businesses that they do. So again, it is only the shareholding pattern that gets transferred to the trust. It is not the underlines in terms of how my business will run, who will take business decisions. All of that will still remain at the company level. So the control of the company still stays with you. It's only the ownership of the company is now in the trust. So there are large business houses which have cross-holding structures, which they're not sure of who owns what. All the cousins and the family members are participating in the business. Everybody is playing an important role there. There are some family members who are too young to play an important role. There are certain family members who are still studying. So in that scenario, if there is a dispute with the family, where is there clarity in terms of what is owned by whom, who owns how much, and that's where family disputes start. If you see, there have been generations going on where none of the large business houses have survived more than 2 or maximum 3 generations. Is because of there being no clarity in terms of family and business. And that is very crucial to look at. That is very important to make note of, to make sure that the families in the future do not get into any kind of a dispute. So we've tried and covered a little bit of advantages of the trust. At the same time, let me show you some documents in terms of how a will would look, or how. So this is your pure will, which has the important clauses. I'm not sure if the screen is big enough for everybody to view, but you could zoom in a little and as per your comfort. But this gives you a clear-cut idea of how a will could purely look at. So it will carry important things like your last will. It says that your last rights and so on and so forth. Other important things that you should look at while forming a will. Okay, there is a very important part of your will. There are families who've written wills which run into like 40 and 50 pages. That's not really required. You don't need to get into doing up a will and writing out things like, I've given the best upbringing to my children. They are this, they are that. Yes, of course, we know that. If you want to write a letter to your family, you could do that separately. But that should not be a part of your will. There are people who've also written, I would like to do organ donation and all of it. Again, that should not be a part of your will, because these are things which are, I mean, in a very normal family like ours, if God forbid someone is not there, the first reaction is not going to be, is there a will? Let's look at the will. So you're going to leave, I mean, that's the last thing on your mind. After all the formalities are done, after everything is done, probably once the family is settled out after with the loss, coming back to normal, that's when you will really look at the will. And in that, if you've written that I would like my last rites to be done in this particular way, or I would like to do organ donation and all of it, so then you're leaving your family with a very heavy heart that they could not live out to your last rites. So these kind of things should not be a part of your will. Your will should be precise, to the point, and carry only the important parts of it. You could also break up your will in two parts by saying that the first part and then the annexures. In that case, if you have assets which are fluid, those could be put in the annexure, and every time you don't need to redo the will, you could have your annexures changed. If it is registered, then it is always advisable that you re-register it. Similarly, if you look at other documents which are the trust deed, a trust deed will be a much more elaborated document which will talk about how what will happen in future, what will happen in a certain situation, what will happen in a different situation. So there are different aspects that are covered in a trust deed. You will also come across families where you say that I would like the assets to go to my wife, and after my wife, I would like the assets to go to the next generation, which is okay, which is what all of us want. But then those kind of things cannot be documented in a will. A will can only take care of the first leg, that okay, after me, it goes to my wife. But if I wish to transfer it to the next generation after my wife, I have to document it in form of a trust, because otherwise, in a will, it will go as per my wife's will and not as per my will. So if her will says that it goes to her sister and brother, sorry, it will go that way. So you cannot control what happens to your assets after you have willed it to one person. But the same can be done in a trust. Uh, there are other important factors of when you really look at forming a succession. It is not just that you have to draft out a document. It is also important on how the document is drafted, because the if and a the can change the entire meaning of the document, and you're not going to really be there to be able to explain what you really meant. So it is important that you spend some amount of time in terms of consultancy and advisory before even getting into drafting. Drafting is the most, I wouldn't say the most easiest, but then that's the last leg. There is a lot of time when you have questions in your mind in terms of, I have agriculture land, I have NRI beneficiaries, how will this happen, how will that happen? And that's where a lot of consultancy and advisory roles will be played in terms of helping you actually understand how assets are transferred and then documented in form of a will or in form of a trust or any of the fields that you feel so. I'll just run through the advantages of trust again. Of course, protection from family dispute is something that we've touched based on. Marital disputes again. Estate duties. Currently in India, there are no estate duties, but the way the law is moving, there is a very high possibility of estate duties coming in. Estate duty means nothing but assets transferring from one generation to another will be subject to certain amount of taxes, which could vary in the range of 30 to 40%. Of course, in development states like US and UK, estate duties are already there. At this moment, very unlikely to predict, but the way the laws are moving, there is a high possibility of estate duties getting introduced in India. A will again not protect you from that, but a trust could. Because in a trust, the assets don't change hands. The assets remain in the trust. The underlying beneficiaries keep changing. Since the assets don't change hands, the part of estate duties don't arise. And that's how development countries like US and UK manage their wealth. So there have been enough advantages and other areas that we've touched upon on a will over a trust or a trust over a will. Of course, there is no right answer to it. It will all depend on a need of a family. There's one more important aspect that you should be aware of, that if you have more of real estate and moving real estate to a trust which is held in individual name today will be subject to stamp duty. So I have assets in two parts. I have movable assets and I have immovable assets. So shares of company, bank accounts, investment portfolios, mutual funds, DMAT, all of that can be moved to the trust without any stamp duty implication. But real estate, I need to re-register the property in the name of the trust, and that would attract stamp duty. So at any point of time, if I am very heavy on real estate, a good idea is to do a combination of a will and a trust, where movables can be moved to the trust today, but immovables can be done through a will. If assets move through a will into a trust later on demise of the person, estate duties will, stamp duty will not apply. Then I would like to spend maybe another 3-5 minutes on business succession. So we've come across a lot of families in terms of large cross holdings where there is no clarity in terms of what is owned by the family or what is owned by the business. And that was exactly the point that I had made even earlier, that that is the most sensitive area which leads to family dispute. You don't know, so there could be a head of the family, which could be one person, but the head of the business could probably be somebody else. And that's where clashes come in, whether it is family business or it is business family. That is one answer which needs a lot more clarity on, because you don't know if the family is controlling the business or the business is controlling the family. When I say business is controlling the family, what I mean is that it is the business that is running the family. So every business, the education is paid from the business, the maintenance for the families are paid from the business, the cars that they buy are owned by the companies, the house that they live in could be owned by the company. So that's where the businesses are controlling the family. Whether so now how much share each one should get, what should happen, what not happens, all of that can lead to complications if there is a dispute within the family. So it is always good to have clarity in terms of what is business income and what is family income. And that you could demarcate by setting it up into separate holding structures. You could have your business assets set in a separate trust, and you could have your personal wealth set up in a separate trust completely. But you could break that up into two very easily and make sure that going forward, there is clarity between the family and zero possibility of a dispute happening. So we can help you in terms of structuring your wealth from start to end. And this is how your business trust could look. You could have a master trust where you could have active participants playing a role in the business. You could also have certain percentage given to passive partners. Maybe your daughter is not an active partner in the company, but you still want to give a certain percentage of the income derived from the company. You may not want to give her the ownership because you don't want the ownership to go out of the family. So every family will have a different need. There is no one size that fits all. It is a pure customized solution for every family. Even a will differ from family to family because the need of the families are different. Going further, you could also appoint more family constitutions. You could do business governance. So again, this is getting into more and more complex structures, which may or may not be required for us at this moment. But in case if there are business houses that are looking for solutions, then those kind of solutions can also be prepared. You could also appoint corporate boards doing different activities under the business, and all of that could be structured around to avoid complexities in the future or any kind of disputes in the future. One very important point which I missed out in the past, which is nominations. There's a set of people who believe that I have done nominations in all my investments, due to which I have planned my success. Yes, that is in a way okay, that you made nominations so that everything goes to the family members in absence of you not being there. But if you go by the legal term, a nominee is only a guardian. he or she is not the rightful owner of that property. So at any point of time, if you have three children and you have appointed a nominee of one of your investments to one child, does that mean that the other two do not have rights over that investment? No, it doesn't. As per the norm, equal distribution to all legal heirs, the role of the nominee is to collect that instrument or investment from the bank or fund house or wherever it is invested into, pool it in a estate pool and distribute it to all legal heirs. But in our minds, we have thought that we made nominees, so the nominee becomes the owner. The other two legal heirs have full rights over that wealth, and that's where again disputes can start. So it is always better to not depend only on nominee, but do up a will at least to take care of any dispute that can arise between the family members. Because the nominee is only a guardian to that property and not a legal heir and not a rightful owner. So we can assist you in the entire end-to-end activity from the time of consultancy, advisory, to getting into implementation depending on need and requirement of the families, drafting out a will, or being it a pure simple will or a little complex will or a will and a combination of a trust. So it is not that every family will need a trust or every family will need business governance, but it is for sure that every family will need succession plan. So from the time of drafting of the will to registrations to assistance in moving assets into a trust to registration of the trust, managing the assets in capacity of a trustee, real estate if you have to putting the property on rent, collecting rent on your behalf, paying property tax, wealth tax, depending on need and requirement of the family. Accordingly, solutions could be provided. Internationally, also we have a presence in Barbados, BVI, Bahamas. So if you're having any cross-holding structures or if you have children living overseas and you're looking at doing up some amount of global solutions, that can also be done very easily. I will leave some time for questions. So, Mona, over to you if you could take the questions now.
Yeah, sure. Thank you very much, Tariq. I think that was extremely insightful and valuable. So we've got a lot of questions from our participants. I'll start with the first one. For NRI specifically, how do they make the will? Do they have to make two different wills for their respective jurisdictions? And do you need to club assets or do you keep it separate? Also, there's anything specific with respect to taxation that one should keep in mind?
Perfect. Okay, as far as NRIs go, it is always better to have an independent will in different countries because the law of the land could vary. So, in case if you do up a will in India, you've registered the will in India. Then, when you execute that will, the court may keep the original with them, or the originals may be stuck in court for probate. You may get it back. They may just give you another letter and keep the original with them. And you will still need the original to be probated or executed in the other countries. So it is either going to delay one of the processes. If you execute India first, international assets will still be frozen because you've not even started that activity because you need an original there also. Or if you start internationally first, then your India assets are frozen because you've still not executed here. So it is always advisable to have independent will for independent states that you are having assets in or independent countries that you're having assets in. You can always give a reference to your assets saying that this will I have prepared specifically for my assets in India and I have made a separate will for my assets in UAE or my assets in London. You should always have an independent will. Again, you could also have one will and then you get those wills notarized in the uh, embassies of that country so that it is recognized by the land of the law and not kept open. So you just don't do up a will in India and don't do anything with the London embassy to get your will notarized or registered there. If that is your interest on doing a one will. But in my view, it is always better to have independent wills and just give a reference in your will that this will does not supersede my will which I have made for my India assets, because then your last will is considered as your final will. As far as taxations go, that again depends on country to country. So if you have assets in the US and you have done up a will, it will depend on the estate duties in the US, and it will go as per the US laws. Whereas if you have a will in India for your Indian assets, it will go as per the laws in India. If you are a US citizen, then global taxation and global estate duties will apply. Again, in there, are you a US domicile or a US non-domicile? Does not matter. If you are a US resident, even if you are living in India, US will tax you on your global assets. So global estate duties will apply. Similarly, if you're a UK resident, but you're a UK non-dom, UK will tax you only on your UK cited assets and not on your non-UK cited assets, which means assets outside the UK. So these are very specific to country laws that will depend. To make it simple, yes, it is better to have two independent wills for your different assets in different countries.
Thank you, Tariq. I hope that answers some of the questions that our participants had. One more question is on registration of wills. So I'm quoting the question. One sibling who gets lesser share challenges the will on flimsy grounds, and then our judicial system takes its own time to make decisions. So does it really help to register the will, and what would you recommend?
Whether registered or not registered, if one sibling feels that he is being left out of the family wealth, he or she has the right to contest for the property or the assets. So whether it's a registered will or a non-registered will, it is still open for contest. And that is where a registered will be better, because what are the grounds of contest? It was done under alcohol influence. It was done under pressure. The person who did the will was not of sound mind, or at the time when he did the will, he was not of sound mind. So all of those small things which can be contested will get automatically addressed if you had registered your will. Because if you have walked up to the registrar office and in front of a registered officer you have done the transaction, which clearly states that you are of sound mind, which clearly states that you are not under alcohol influence. So all of these baseless accusations that may arise can get addressed if you had a registered will. A registered will also help in certain states where probate is not mandatory. Over there, also a registered will hold more weightage than an unregistered will. So in my view, it is always better to register a will, but by law, it is not still mandatory to register your will.
Absolutely. Thanks, Tariq. The next question is on the costs associated with setting up a trust. So what are the typical costs which are associated? And we have one more question on what, when somebody is looking at a company for their succession and estate planning, what is the range of services that they should be looking at to make sure that they're going to the right firm for their requirements?
Okay. One is that if you need a specialist, you go to a specialist. You do not go to a general physician at that point of time. So if you have specialized companies like Amicorp, which specialize in a particular service, it is better to go to a organization like Amicorp, if not Amicorp, that's your choice, who will be able to give you an end-to-end solution. You could also go to your lawyer. A lawyer is understanding legal framework. He will be able to draft your will or your trust deed for you. But again, a lawyer will not be able to give you tax advice around it. So you have very strong lawyers who are litigation lawyers, corporate lawyers, real estate lawyers, but you do not have a succession planning specialist lawyer. There is no one in India which is a succession planning specialist lawyer who will be able to tell you Indian assets, global assets, cross-border taxations, everything in one point of time. Okay, so how will you identify a right person? If I am looking at cross-border taxations, I have children in India, I have assets overseas, my children are NRIs, I am an NRI, I may need some solution in India, I may need some solution in my home country. Then I rather look at an organization which is probably present in both locations. If I'm looking at pure domestic assets, then I'm okay to go to an organization which is only domestic and nothing to do with offshore. But it is always advisable to maybe get more than one consultancy done and then take a call as to where you feel you're getting the best solution, or uh, you feel that your needs are met. If you're looking at only drafting out a will, then are you looking at consultancy before drafting the will? Because the important part is not just drafting the will. The important part is how to go about the entire proceeds. I have different kinds of assets. How will each one be treated? So it is important that you get the right consultancy even before drafting of the will. As far as charges go, the charges, I can talk about our charges, which are not linked to AUM. So if you are a wealthy family, it doesn't mean that my fees to you is going to be high, because our charges are not linked to AUM. Our charges are linked to complexity and scope of work. So you have an example, you have one family which has got a lot of wealth, but one child, everything is very streamlined. There are no cross holdings, no uncle auntie sharing, nothing of that kind. My fees to them will be far lesser than a family with maybe 50% of the wealth of the previous one, but having cross holdings, a lot of complications. Cousins are also there. Father's brother is also a partner of the company. There's joint property between all of them. So my fees will not be linked to the AUM or assets. It will be linked to complexity and scope of work. Said that, we have a special pricing and a preferred pricing for Yes Bank clients, and you will get full advantage of that.
Yeah, thanks, Tariq. The next question is on individuals and HUF. So do they have to make different wills for the same one? Similarly, there's one more question where whether the husband and wife, do they make a joint will, or do they make individual wills when it comes to planning their succession?
Okay, so whoever asked this question of joint will, thank you so much for bringing that up. We also believe in ourselves that I have joint property. I have everything in my name, and or I have property which is joint between me and my wife. So in that case, I don't need to plan my succession because everything is joint. But if you really look at it, it is equally important for you to plan your succession because only 50% of your wealth is yours. 50% is not yours. So if I am a Hindu family and I have one property distributed owned between me and my wife. So on my demise, my wife will not become 100% owner of the property because she is a second owner or a joint applicant or a joint owner of the property. My 50% will go as per my succession, which means that it will go to all legal heirs. So if I have two children and a wife, my 50% will get distributed to three of them in equal proportion. And my wife, being a joint applicant of my property, does not become the 100% by default owner of my property. And that is a big misconception in people's mind. Similarly, your bank accounts, everything is joint. Why do I need to plan my succession? No. If you go by the legal term, if a bank account is in joint name and on decease of one person, the right steps are that the account will be frozen. So the moment you go to a bank and provide a death certificate, the account will be frozen. So it's either a survivor is only good while both of them are alive. But if the moment one person is not there and you go to a bank with a death certificate, a smart RM will tell you, remove the money, then give the death certificate. Otherwise, those accounts are frozen. So that's a very important aspect to look at. Joint are only good while both are alive. Similarly, whether should I do a single will or a joint will? In my view, I would strongly discourage people from doing a joint will, because again, if one person is no more, the will is any which null and void for the second person, because he or she can is going to inherit a lot more assets and will need to change his or her will. Even if you don't change your will, probating a probated will becomes very difficult. Also, if the original will is being kept in the court, then you don't have an original for the second person. So you have a mirror will or a similar will, but you always have two independent wills for two family members, husband, wife joint. No, but you have an individual will for all of each family member.
We'll now take the second last question. This is on creditors. So does a trust provide protection from creditors?
Yes. Again, the Insolvency Act is what you have to look into. So if you have, say for example, I have set up a trust today and I have not moved any of my assets into a trust. And 6 months down the line, I foresee something coming my way and I immediately decide to move my assets into a trust and assuming that it will protect me from creditors. That is totally wrong, because anything which is done within 2 years can be revoked back. So if I set up a trust today and I move my assets into a trust and I declare bankruptcy after 6 months, the law is very clear that this has been planned. You were foreseeing this coming, due to which you moved your assets into a trust. But if I set up a trust today, I move my assets into a trust, and 3 years down the line, something goes wrong. In that case, the assets of the trust are ring-fenced and protected and cannot be attached, because the law says that I cannot be planning for so long. So there is a cutoff period of 2 years, which is the Insolvency Act, said that the trust has to be then designed in that particular manner. It cannot be a revocable trust. You cannot be retaining control in that trust. You cannot be a beneficiary of that trust. So you have to be very clear in your mind that this is an asset protection or a ring fencing trust that I'm looking at. If you make a generic trust and you say that I will have control over it also, I will be a beneficiary of that trust also, and I also want asset protection, no, will not work then. So for an asset protection trust, it has to be dealt with utmost carefulness, and it has to be specifically designed.
Thank you. So we'll just take one last question as we're nearing the end of the session time. This question is basically on, do you need to revise the will after marriage? So that's a question from one of our clients, that post-marriage, do we need to make any changes to the will?
If you are a Hindu family again, legally you don't have to revise your will, but since you have new family members that have joined in now, then you will have children, so you will want to relook at your beneficiaries, because earlier you had beneficiaries which were different than the new family members that have joined in, and children who you may want to appoint as a beneficiary. But legally, no, you don't have to forcefully relook at your will. But if you are a Christian family or a Parsi family, then by default a will is considered null and void on demise on marriage. So if you are not married, and you have done a will before marriage, specifically for a Christian and Parsi family, on marriage, the will is considered null and void. And by law, you're forced to write another will. And the logic behind it is that they believe that before marriage, your priorities were different. After marriage, your priorities are different, due to which you should relook at your will. But that is only applicable for a Christian or Parsi family, not for others.
Thank you very much, Mr. Aboobaker. I would like to thank you on behalf of Yes Bank for sparing time today and sharing these insights. Thank you to all our customers for your participation. We hope that you found the session very insightful. We will continue to bring many more such initiatives to empower you with the right knowledge to take the right decisions. Stay safe. Thank you very much. Thank you.
Thank you, everybody.